I'm sorry. This is good. Would you ever prefer it to be over there? We can move it, obviously. It's up to you. I just want it to be where you can see it. I'm sorry. I'm really trying not to mess that stuff up. I saw I was, right. Some procedure, so this is John. I didn't arrange for me to go on my side, if I'll be dirty on mine, we'll pay for it, should work. somebody wants to take all. That's what we're trying on.
Yeah.
Would y'all like to do it?
Sure, plan on just doing, we go through, we go through, back to back, and then go through all the witnesses. And then,
So, well, let me ask y'all, do you want, we have there to do separate, you know, we want to have it, and it's gonna out just one time. Yeah, you know, I heard that.
oh, I don't,
Cause I think, you know, we have muted, like, you know, going off.
the same thing. Actually, I'm not sure.
Long time no see. At least a few weeks, I guess. I didn't get one.
But it would still, yeah.
So you gotta go.
I mean, I know it ain't something wrong.
I mean, do you guys have cases? Do you have cases?
Oh, yeah. Sounds like my son.
Tell us the
Yeah. Then you present your evidence, we'll present our evidence.
I agree. Yes. What I told
all of the stuff that was good. This is that.
situation. Because it's not. It's just me sort of giving exhibits and talking about the law. I've got this for you. But it's just very.
Counselor, y'all about ready?
Yes, we're about ready, we just wanted to, try to streamline it for y'all.
We just want to make sure.
You know, sure.
Second.
So, because I mean, you obviously, if there's something you want to say, if you want to set it up so that they understand the framework of this. I assume it will be a contested issue and quality.
Hello?
Gentlemen, you all set?
Okay, cool.
Chairman's walking in, so we're good for. We'll give her a few
Sorry,
minutes.
I'm not trying to take care.
I'll let him go ahead and read what we have, and then I'll send a remodel.
Bear with us, we have a board member on the way in. Just another minute.
Now everybody got the voice.
Oh, okay.
I'm sorry, I apologize. I'm sorry, I didn't listen to Jerry.
Oh, okay.
I apologize.
Okay, thank you.
Very well.
Okay, we're all present now, so we're gonna go ahead and get started. We are just a couple minutes late. I apologize. Welcome to our meeting today. Today we are holding a public hearing to determine whether two candidates for sheriff of Bibb County are qualified to hold the office. The hearings will be conducted as set forth in OCGA section 21-2-6. Challenges were initiated by this board. The grounds for the challenges are that the candidates are not qualified to hold the office of sheriff because they failed to comply with OCGA section 15-16-1C1G, which provides a relevant part as follows, quote, "No person shall be eligible to hold the office of sheriff unless such person is fingerprinted and a search made of local, state, and national fingerprint files to disclose any criminal record, which fingerprints are to be taken under the direction of the judge of the probate court of the county in which such person is qualified and must be taken on or before, but no later than the close of business on the third business day following the close of such qualification period. It is the board's understanding that two candidates for sheriff, Ronald Rogers and Marshall Hughes, were not fingerprinted within the time period required by section 15-16-1C1G. The hearings as to each candidate will be held separately. Each hearing will allow the same general procedure. The board's attorney, William Nolan, will present evidence on behalf of the board. The candidate or his counsel will have the opportunity to review any documents and cross-examine any witnesses presented by Mr. Nolan. The candidate or his counsel will then present evidence in the form of documents and or witness testimony. Mr. Nolan will have the opportunity to review any documents and cross-examine any witnesses presented by the candidates. Mr. Nolan will have an opportunity to present rebuttal evidence if any is required. The candidate or his counsel may address the board with a closing argument or statement. Mr. Nolan may address the board with a closing argument or statement. The board will then vote on the following question: is the candidate qualified to hold the office of sheriff in Bibb County? An affirmative vote means qualified, a negative vote means disqualified. Once the decision is made, it will be reduced to writing and served on the candidate. At this time, we will begin the challenge hearing with Marshall Hughes.
Mr. Chair, if I may, just make a couple of remarks, and to fill the board in on what the lawyers were huddled up about just before the hearing. It makes sense, if the chair will allow it, first I'll make some brief remarks, and then counsel for Mr. Rogers, John Bay, and counsel for Mr. Hughes, Joe Siegelman, will make remarks, and then we may, if it's okay with the board, take the testimony just one time and have it apply to both hearings. It's been my understanding that while both lawyers will want to ask questions of the witnesses, none of us think it's necessary to call them all twice to the extent we have that. So if the board will allow that, we'll proceed in that fashion and have one hearing of two separate issues. All right. And I'm not going to make very long opening remarks. I will turn it over to counsel for the candidates, but Mr. Chair, I think you summarized the nature of the proceeding just right. We're just here to decide whether the candidates complied with the, number one, whether they complied with the fingerprint deadline within 3 business days after the end of qualifying. And I think probably more importantly, whether that disqualifies them to serve as sheriff and thus disqualifies them from serving as, to continue to serve the candidate in the election. The board has made a decision to bring this challenge, and I understand the board's going to hear from both sides. One thing I want to start with, and ask the parties, I'm sorry. I have marked exhibits for each of the candidates, and I've used the first letter of their last name, so R1 and R2 for Mr. Rogers, and H1 and H2 for Mr. Hughes. Now, the first document is just the hearing procedure, which everyone has, and the court had just read it. This may be unnecessary, particularly in light of the fact that we're altering it, but it's here. The more important is number 2, which would be Arthur H. Depending, which are simply the hearing notices, the letters coming back, and then the qualifying packet, which we would submit as admissible as a public record. I'll ask if the parties will stipulate to this being included in the record. It does have the probate court document in the back that is part of the qualifying packet.
I said no objection.
Yeah, so stipulated.
Thank you. That's my fault for standing. Thank you. So we'll have that. And I will be relying primarily on these documents in the record in making my presentation. But for now, I'd like to turn it over in whatever order council decides to allow counsel for the candidates to speak.
Good afternoon. Appreciate y'all giving us an opportunity to come here. My name is John Bay.
Thank you, Mr. Day.
Law firm Bay and Associates, and I have the honor of representing Ron Rogers.
Thank you.
Look, it's our position that this is, in fact, a very simple case. Ron Rogers has been post-certified for over 30 years. He has had background checks for over 30 years. He has had fingerprints for over 30 years. In fact, he has more extensive training and exact hours that he has to get 20 every year because he has even more certification. And all of these things go to the same database, which is NCIC. Now, you're going to hear testimony today. Let me say this before I get any further. We have kind of divided some things up so that you don't have to hear from us twice on the same thing. So we're not going to, please don't mistake us coming here and dividing it up as it not being important enough to go over twice. We just felt for the board's purposes, you may have other things to do today, and we wanted to make sure that you all had time. But let me talk about these statutes for a second. This is really born out of what is subsection C1. And what co-counsel is going to talk about later is how C1 and C2 were the exact same thing. Now, that's until 2015, when C3 was there. And C3 was the exact same thing as C2. And now, what that makes sense is, if C1 is the same as C2, and C2 is the same as C3, then C3 is in fact the same as C1. We'll go into more detail on that, but just keep in mind, it's just simple arithmetic. If one is equal to the other, then they're treated the same. Now, there's a precedent since 2015, and there's been one sheriff in Muskogee County who was allowed to remain on the ballot. There's been one sheriff in Cobb County who's been allowed to remain on the ballot. So if the board were to do anything different here, they would be doing something that is different than what has been done. They would be doing something that is different than what has been decided by the superior courts, in the only other cases that have been decided based on this. Now, we also have the issue, you're going to hear evidence today about disparate treatment. You're going to hear that one person walks into the election board office, gets qualified, doesn't ask any questions, and is sent on his way. You're going to hear evidence that another person walks in and said, "Is everything okay? Am I good to go?" And is told yes. You're going to hear evidence that a third person walks in and is told, comes in with their fingerprints and said, no, that's the wrong place. You got to go over here. And that person wouldn't even be qualified on the ballot had they not gotten that information. So really what we're looking at here, and we got another two or three folks who we don't know what happened. So really what we're looking at here is, how was every candidate treated, and was there disparate treatment there as well? So in closing, this is a lot like an onion. You start peeling this onion, and your eyes start to water a little bit. We start peeling it more and more, and we look more at this, and you start peeling out more. And what we're asking you to do here today is to do what the president will show you, and don't do anything different. Allow them to stay on the ballot, just like Muskogee County did. Allow them to stay on the ballot, just like Cobb County did. And let's not get into litigation and start rubbing our eyes and creating more of an issue. Because at the end of the day, I think we're all on the same team. We all want the citizens of Bibb County to be able to make a decision on who their next sheriff will be. And we shouldn't eliminate anyone for any reason that we don't have justification for. Now I'm going to show you just a couple of slides here. And these are from the ruling in that Muskogee County case. And it says here, statutes which limit an individual's right to hold office must be construed broadly in favor of who? Those who are seeking the office. In words that limit the right of a person to hold office are being given a liberal construction in favor of those seeking to hold office, in order that the public, here that being the citizens of Bibb County, may have the benefit of choice from all those who are in fact qualified. And finally, there's this graphic. And I just want you to think of this analogy. They've already said 2 times that in C3, it opens up the lock and the person is allowed to stay on the ballot. If that same key, if all of those clauses are the same, if that key opens clause 3, then it opens clause 2, and it opens clause 1. And we respectfully request that our client stay on the ballot. Thank you.
Good afternoon. My name is Joe Siegelman. I'm with law firm Childress Scrubman, and have the privilege today of representing Mr. Marshall Hughes, a candidate for sheriff. As the board, I think, is already aware, and as the party stipulated to the information that the counsel for the board presented, there isn't much in the form of disputed facts. We all pretty much understand what happened. And the candidates aren't here to tell the board, well, I actually did have my fingerprinting done within the time period of 15-16-1. We aren't here to dispute that or have some factual determination. So What the board's job is today, and I think you all understand and appreciate this, and we certainly recognize and do, is there's largely a legal question to be decided. And that is whether these two gentlemen, but my client again is Mr. Hughes, is whether or not he is qualified, according to the laws, to be on the ballot for sheriff. And so although we do have some witnesses to get certain information from for the benefit of the board, again, this is largely a legal determination. And I want to start just with the notice that was in the documents agreed to by all parties that counsel for the board presented. And I really just want to start with the very first document, which is the notice. It appears to be on just the second page. So the statutory provision that we're here to discuss today it certainly seems fairly clear. It says no person shall be eligible to hold the office of sheriff unless such person, I'll paraphrase, obtains the fingerprinting specified in the section within 3 business days after qualifying. Right? If you ask any lawyer their opinion of that statute without a detailed understanding of the underlying law, historical case decisions, and you talk to them about the circumstances of this case, they will tell you, well, it sure seems like they should be disqualified. And we don't we don't hold anything against the board for issuing this notice and having the questions that the board has. And if anything, we are collectively greatly appreciative to the board's attention, to the board's consideration, and the opportunity to explain certainly what we understand the nature of the law to be. And I would contend, even if this board was the Secretary of State, even if you had the benefit of any attorney, with the Secretary of State, I wouldn't be surprised if they themselves said the same thing. And the reason is, one, the Secretary of State generally handles statewide issues and not generally local issues. But they can't be expected to understand the specific qualifications for every office, in particular local offices, and what implications each particular qualifying criteria, or to the extent it's part of the qualifying criteria, to the extent it applies. So that's why we're here today. That is certainly the main reason, at least, why we're here today. And so to that end, I want to start where counsel for Mr. Rogers left off, which is the right slide here. Which is this. So statutes which limit an individual's right to hold office must be construed broadly in favor of those seeking office. Okay, so that's the law of the land. The law of the land is, if there are dueling interpretations or if there are questions about an interpretation, we have to err on the side of keeping the candidate on the ballot. That's what the law says. So, is there a question here, or is it clear? That's what we intend to establish. But as we go through the evidence and law and statutes that we're presenting to you today, I just want the board to keep in mind this language, that if there's a reason to keep someone on the ballot, if there's a question in the law, that's what we're here to do. We are here to give the people of Bibb County the greatest amount of choice from all those who are in fact and in law qualified. And I also want to point out, while we stipulated to the documents that the counsel for the board gave to you a moment ago, everybody here has stipulated as well that I know for certain for Mr. Hughes, but I believe as well for Mr. Rogers, that the substantive qualifications, are met by these candidates. I won't go through those at this time. I think that's more appropriate for testimony, but As far as whether they are in fact qualified, there's no dispute. They have all the attributes, they possess the attributes to be sheriff. The question is, are they procedurally barred because of a procedural misstep? That's the question. And whether the law requires, because of a procedural misstep, that they be disqualified. I submit to you that it doesn't, and we can demonstrate that to you today. I could stop there, depending on the preference of the board, as my discussion of the law, or I can proceed, given that so much of this hinges on the status of the law in the state. If the board would like, I can proceed into specific details. I will pause regardless for a moment to say that in addition to what I've already stated, there are questions that were raised by Councilman Mr. Rogers as to whether each candidate who qualified was treated the same, whether they got all the same information. And although it's axiomatic that we expect all candidates to be treated the same and they should get all the same information, that's not exactly what occurred here. And there's case law that says that in and of itself can be an unlawful process and can be a reason for a challenge to the qualifications process. So we do intend to get into that. And there's also going to be testimony that Mr. Hughes specifically sought out answers to ensure that he had done everything correctly. He came out and qualified on the first day of qualifying, March 4th. It wasn't Friday the 8th at noon, right at the cutoff. It wasn't at 11:30. It was Monday. You know, he set out to do everything right. He asked if he had done everything right, and I believe the testimony will show that he got an answer that he had when, as we all know and are here today to discuss, the fingerprinting was not yet completed. So with that, I'll defer to the board as well as counsel for the board as to whether I should proceed on discussion of the legal circumstances we are in today.
For my part, as counsel to the board, I have no preference. If you all wish to continue forward with argument, I'm fine. I'll leave it to the chair.
All right. I think for efficiency's sake, it makes sense to do so. So I started out by saying, if you look at the provision that's quoted, 100 out of 100 lawyers looking at that are going to tell you, yeah, it seems that they didn't turn in their fingerprints within the third day, they should be disqualified. That's understandable. There's also the reason why we have courts to interpret words such as that we believe weigh heavy on this case, and to determine what exactly we should make of language that certainly might seem clear, but might necessarily not be. So fortunately for us, there is a Supreme Court case that took up the issue of whether missing the fingerprinting requirement would disqualify you as a candidate. That's helpful. I'm going to hand each of you a copy of that case. I'm going to hand one to first to counsel for the board. There's highlighting on the first page and the second page. Right now, I intend to discuss only the first page. Absolutely. And I'm going to read the highlighted portion. We hold that the deadline stated in Code Annotated Section 24-2801, C1G and C2 are applicable to a person seeking by primary election his party's nomination as candidate for the office of county sheriff. Now, you might be wondering, well, what is 24-2801? Because that is not the code section that we're here today to discuss. That code section is 1516.1. So this case is a 1980 case. That means that it is more than 40 years old. And the law was different back in 1980. Now, the premise of what I've highlighted is important. That the court considered C1 and C2 to be equivalent when it comes to qualifying. So for our purposes, all right, C1 equals C2, right? That's what the Supreme Court of our state said. In 1980, that the C1G requirement and C2 are both applicable to a person seeking qualification. And if you continue reading, it says that they could warrant disqualifying the candidate, both C1 and C2. So you heard me say that the code section that's referenced, and you can see it for yourself, cites to a 24-2801 in 1980. That's what this code section was called. I'm going to hand you what the law was in 1980. This, don't be confused, at the top it says 2002, but the law didn't change between 1980 and 2002. So this is what the Supreme Court of Georgia was looking at the time that they made this 1980 decision. And you'll notice there's two different colors of highlighting on this page, and I'll go over each of them and why I've highlighted them differently and their importance. But you can see in the orange highlighting where it says subsection C, qualifications, no person shall be eligible to hold the office of sheriff unless such person, and it lists details. And then, again, also under that subsection C of qualifications, the language there says, under section 2, it says each person offering his or her candidacy for the office of sheriff shall. The reason why those are both highlighted and highlighted in orange is because the Supreme Court considered them equivalent. So that's why they're highlighted the same color. So you can see that the language is different, but the Supreme Court considers them both equally applicable to candidates running for sheriff. The other important part of this statute, and this is highlighted in yellow, under C1G, the close of qualifying is when fingerprints must be submitted. The close of qualifying. That's not what it is today. It's 3 days. If you can look at subsection C2, it says at the time such person qualifies. Now, the reason why that is important is it is quite logical to think that if something must be completed by the day of qualifying, it's part of the qualifying criteria. If it must be done by the date of qualifying, and a candidate's qualifications are determined on the date of qualifying, then it must be needed. And that's exactly what the Supreme Court said in 1980 when it interpreted these sections. It said the requirements of C1G and C2, as I just showed you, it says they must be completed by the date of qualifying. And if they aren't, then that person's not qualified. But again, it's not the law anymore. The law changed. I believe Council for Mr. Rogers said 2015. I'm going to confirm, but I think it was 2013 when the legislature decided to make some changes. So I'm going to hand you a copy of the bill that passed the State House and Senate and the General Assembly in 2013 and was signed by the governor. Once again, because I like the color code things, there are two different sets of highlights, some in orange, some in yellow. So what did the legislature do in 2013? And if you need a minute to look at what I sent you, feel free, but I am going to walk through it. The legislature in 2013 made two changes. You'll be able to spot them easily enough. What did they do? They added subsection C3, and to certain provisions, they allowed candidates to submit certain paperwork within 3 days. One of those sections was C1G, the subsection we're here today. The other two were C2 and the new section C3. I also want to point out in this, the yellow highlight. The opening language of C3 states, each person offering his or her candidacy for the office of sheriff shall. If you look right above at C2, it's the exact same language that was used in C2. Each person offering his or her candidacy for the office of sheriff shall complete whatever subsection C2 and whatever subsection C3 states. Because of that, and quite clearly by the language, whatever is required in C2 is also whatever is required in C3 and C2, both must be completed because they both use the same language. So now we know C2 equals C3. Now, I'm no mathematician, and I can't even tell you for sure that this principle came out of math class, but it's an easy one. The principle is, I think it's the transitive property, but if A equals B and B equals C, then A must equal C, right? So if we know from the Supreme Court, C1 is considered the same, on the same level as C2, and we know from the legislature, because they included the exact same language for C2 and C3, that C2 and C3, they're equal. So what does that mean? That means C1 necessarily equals C3. We also know, and this is equally important, legislature made two changes. That's it. They added C3, and then they added to certain provisions, only to certain ones, this 3 business day dangling procedural requirement. The close of business on the 3rd business day, and that's highlighted in orange, and you can see that exists only in section C2, C3, and C1G. Now, whatever the legislature's intent regarding that dangling 3-day procedural requirement, you can be sure that they meant it to apply to C13 or C1G, C2, and C3, because it's the same, and they added it for all 3 of those sections. Well, where are we today? Today is not 1980. Today is 2024. We have an intervening legislative act materially changing the language of the section at issue and that the Supreme Court considered. Now, the language in C1G and C2 that made them equivalent, that's the same. So C1 and C2 being equivalent, that still holds. But the dangling procedural requirement of 3 days, that changed. It is no longer at the close of qualifying. It is 3 days after qualifying. Now, has there been any case law that has interpreted C1G, C2, or C3 since 1980? We're in luck. There has been. Now, there's been no case law that we're aware of that's interpreted C1 since that Supreme Court case. the 1980 case. We're not aware of one that's interpreted C2. But there are two cases that have considered the 3-day requirement in C3. Those two cases were out of Muskogee County in 2016 and out of Cobb County in 2020, Superior Court cases. In both of those cases, the Board of Elections read this language, but it's similar language in C1 as it is C2 and C3, that says, you gotta do this by the 3rd day. And the boards of elections for Muskogee County and Cobb County said it wasn't done in 3 days. Therefore, we're disqualifying you as candidates. Well, what did the superior courts do in Muskogee County and in Cobb County? They reversed. In 2016, Donna Tompkins was a candidate for sheriff. She went on to win the 2016 election in Muskogee County. And she remained sheriff through 2020 when she ran for re-election and did not prevail in the re-election. But there was no subsequent legal action, there was no appeal, there was no further challenge of what the Superior Court did interpreting C3 and that 3-day requirement. I can give the board those citations. I can give those to counsel for the board. And indeed, some of these quotes that we're showing you are actually from the 2016 Muskogee case. I'll admit to you, and this is public record, readily available, there wasn't much substance in the Cobb County case, they just said the board is reversed. But the Muskogee case had some law in it, so we're showing some of that to you today, but the decision was the same. So what they held that if the legislature intended for these criteria to be part of the substantive qualifications that determine whether you can be qualified to run for sheriff, that it would not have been 3 days after the fact. It would have been part of what has to be done by the date of qualifying, which is what it was before. When the Supreme Court in 1980 made the decision that they did, the legislature changed that. And the Superior Courts found this is part of what they found. To give effect to the intention of the legislature, courts are not controlled by the literal meaning of the statute, but the spirit or intention of the law prevails over the letter. This is another Supreme Court case, and this is cited in the 2016 case, which, although there's not language to this effect, I presume was adopted in the 2020 Cobb County case. But where the letter of the statute would result in an injustice, the meaning of the general language may be restrained by the spirit or the reason of the statute. And it's the duty of the court to consider all of that information and not to be bound by this literal meaning of the statute. So there are only two cases since the legislative change in 2013, both of them cited consistently. Both of them. It's not dueling decisions where we don't know what a court's interpretation was. The courts ruled the same. And the one takeaway that is consistent, that hasn't changed since 1980, is that C1 and C2 are the same. And the legislature said C2 and C3 are the same. So if two courts in 2016 and 2020 have said that the 3-day dangling procedural requirement does not keep a sheriff candidate off the ballot, then the same should hold true for C1. Now I'm going to show you one more statute that we believe is relevant to these proceedings. This is the law. It talks about the qualifications of candidates for county office and further the challenging of those qualifications. I may discuss more of the statute, but I've highlighted on the very first page the process for challenging a candidate's qualifications. And it states, within 2 weeks after the deadline for qualifying, any elector who is eligible to vote for any such candidate may challenge the qualifications of the candidate. Again, starting at the deadline for qualifying. Now, here's something that's interesting. The 2016-2020 cases that interpreted the 2013 change to the law found, as we've already discussed, a 3-day dangling procedural requirement should not be held to invalidate an otherwise qualified candidate. That's what the holding of those cases. And here, the legislature didn't change this statute. They're already making changes to the qualifications of county candidates. But they left in this 2-week requirement, even though if a candidate should be disqualified 3 days later, that would mean that the deadline for qualifying is actually, like, the determination of qualifications isn't on the deadline of qualifying, it's 3 days later. And that's when you would have 2 weeks, presumably. So if the legislature had the intent of these dangling 3-day requirements that we see in C1G, C2, and C3, we've already been over. If they had the intent of that being a disqualifying criteria, they would have done one of two things. They would have either left it, as this is important for qualifications, it has to be done by the close of qualifying, full stop, it's part of qualification. Or they would have changed this. They would have said that the deadline for qualifying determines the qualifications of the candidate, and you have 2 weeks from there to challenge their qualifications. The absence of any change to this provision strongly indicates that the interpretations by the courts in 2016 and 2020 was the legislative intent, was consistent with the legislative intent that these 3-day requirements are not actually part of the substantive qualifications that are necessary to hold the office of sheriff. And more than that, the legislature included the intent of their actions in the very first subsection of the code section we're under, 1516.1, talks about A, intent. And the intent is to have someone who has the attributes to possess the qualifications of sheriff that will make them serve well in that position. And that is already stipulated. There's no dispute, certainly as Mr. Hughes, I believe as Mr. Rogers, that these men, Mr. Hughes possesses the attributes that are part of the substantive qualifications to hold this office. And the only case law that we have interpreting these dangling 3-day requirements that the legislature equally applied to the 3 sections we've discussed is that they don't keep somebody off the ballot. They shouldn't keep somebody off the ballot. And in so doing, they reversed 2 boards of elections that thought otherwise. And again, I'll end my discussion of this legal portion exactly how I started it, which is, if you ask 100 lawyers to look at this code section and to tell you whether if somebody submits their fingerprints on the 4th or 5th day or thereafter, a week later, does that disqualify? And 100 out of 100 lawyers with that limited knowledge, without knowing what the Supreme Court did in 1980, without knowing what the legislature did in 2013, without knowing what Muskogee County did in 2016, and what Cobb County did right after in 2020, every lawyer is going to tell you, well, that seems like it's disqualifying. And I don't blame the board. I wouldn't blame the lawyer who said that, because it's understandable. And I understand why we're here, and that's also why I said at the beginning how grateful Mr. Hughes is for this opportunity to come before you, to talk about all this, to try to avoid peeling back any more of an onion to cost, whether it's the county or either of these parties, any money trying to file a court case that we know and can tell And we can tell just by the extensions that this board has given, that you want to get it right. And we're here to try to help you get it right, for all of our sakes. And at the end of the day, this is why we're here. We are not here to limit the right of a person to hold office. We want to give a liberal construction in favor of those seeking to hold office. And we want the public to have the benefit of choice from all those who are in fact and in law qualified. And that's exactly what we have today. And finally, I have to note that the Superior Court, in fact, didn't have trouble with this. Although a plain reading of the statute seems to indicate one result, they found that it was a clearly erroneous decision to hold these candidates off the ballot. That it, in fact, was arbitrary and unwarranted exercise of discretion. And further, that it violated the laws of the state, not inconsistent, but violated. And that it was indeed error of law. So this is not we're not sure what to do, it's a close call. It's the legislature acted. This is a dangling procedural component that falls after the qualifying period. And there is no clear legislative intent that they meant for these dangling procedural requirements to prevent someone from being on the ballot. And in fact, if you look at other provisions in the elections code, like the one I just gave you, it indicates the exact opposite. It indicates that they meant for these 3-day requirements to be a procedural, non-disqualifying component. And if they wanted them to be a part of the qualifying criteria, they would have left it. They either would have left it as the day, the deadline of qualifying, or they would have changed this provision that states the deadline for qualifying determines the qualifications of the candidate. Again, those candidates in 2016, Muskogee County Sheriff Donna Tompkins served all 4 years after winning the election. No subsequent challenge, and indeed the law seems clear enough that had there been any challenge, it either would have been precluded by law because of the decision that's already been rendered, or they would have lost on the substance. Same with Sheriff Craig Owens in Cobb County, who served in 2020 and 2024, still serving and seeking re-election. Both of those cases involve subsection C3, the same 3-day requirement. So that's in essence what the law is, the applicable law in this situation. I'm happy to answer any questions to the extent that's appropriate. I believe this is probably more appropriate in conclusion of our comments after witness testimony. But as I started out saying, this is a legal question by and large. The parties have largely stipulated as to what the facts are. You know, we know that we're here because the fingerprints weren't submitted, but within the 3 days. But as you'll hear, they were submitted immediately upon notification. I believe that will be in the testimony. And if the board wishes, if counsel for the board would prefer, we would welcome the chance to provide some sort of briefing to the board, legal briefing, so that this can be laid out as opposed to just my verbal presentation here today. Obviously, if that's all you need, so be it, but we wanted to make that offer. Again, we do have some testimony that we believe is relevant and pertinent to the board's decision that could help inform the appropriate decision, and we look forward to that opportunity. But at this moment, I know that was a lengthy presentation, a lengthy open, but I believe it was necessary. And again, while we hear from these witnesses, let's continue to keep this law in mind. The statutes which limit an individual's right to hold office must be construed broadly. And again, to the extent there is any doubt in this board's mind as to whether or not these men, but I find again Mr. Hughes, should be allowed to remain on the ballot, you err on the side, law says, not me, the law says you err on the side of keeping that candidate on the ballot to the extent there is a remaining question and you're not convinced definitively on the status of the law. With that, I will sit down to conclude my opening remarks. Look forward to discussing with you further and with the witnesses that are called. And again, to the extent appropriate, or the board has any questions, I welcome any questions from the board.
I'll reserve, on behalf of the board, I will reserve my rebuttal to the legal arguments until that testimony is taken. I did not intend to call any witnesses. I believe as Mr. Siegelman and I believe Mr. Bay pointed out, facts are largely stipulated to, and they are contained within the exhibits R2 and H2. And again, I will address the legal arguments at the conclusion. I'll turn it over to counsel for the candidates for any discussion.
We'll call our first witness, Mr. Ronald Rogers.
This item is a witness chair.
Oh, witness chair.
It's near the court reporter. That's why it's qualified.
Well, luckily I'm calling a mock trial coach, so he used the chair before.
That's true. That is true.
Mr. Rogers, thank you for coming out today. I'm just going to ask you a couple quick questions. Now, could you just tell the board how long you've been post-certified?
For over 30 years,
Okay. And so how long have your fingerprints been in the system?
for over 30 years,
Okay, and how long has your background check been in the system?
for over 30 years.
Could you explain to the board what it means for you to get those 20 hours of executive certification?
So each year, I have to take courses that are for executives and executives only for law enforcement agencies. And we do that once, sometimes twice a year, depending on the courses that you want to take. And so each year I go to Savannah and I take over 20 hours to keep my law enforcement executive certification.
Okay, now in those entire 30 years, has there ever been an issue with your post-certification?
No, sir.
Has it? Oh, sorry.
So each year I have to recertify. Post allows us to go online and actually put in our testimony that we haven't been convicted of any crimes. And of course, also for the Board of Education. So we have to do that each year.
So what, if anything, was significant about the same week that you qualified? With respect to your
I
certification?
actually recertified my testimony that I haven't been arrested or anything like that. Actually, that same week.
That same week?
Yes, sir.
And now, is it your understanding that all this information all goes to the same database?
Yes.
And what's that database?
The National Crime Information Center.
Okay.
Also known as NCIC.
Okay. Now, the information goes to the database. Now, when you walked in there, did anybody tell you to do anything else after you got qualified?
No.
When you left, did you feel like you were qualified?
Yes, sir.
Okay, and when you got a phone call, I believe it was on the following Friday, where did you immediately go?
I went to the probate court.
Were you able to get fingerprinted or background check that day?
No, the young lady wasn't there.
Okay, and so did you follow back up on Monday?
Yes, I did.
And then what happened?
I was able to get my background check done and my fingerprint done the exact day. And within the hour, it came back, of course, with no issues.
Okay. I'm gonna show you something right here. I will also share it with Olin and before. Could you tell us what, I'm sorry, you don't have to share, I got it.
It's in the packet.
We have that.
Could you tell us what that is?
This is what the probate officer and the probate court provided us once we taken our background check.
Okay, so there would have been no issue to disqualify you in the background check or the fingerprint?
No, sir. No, sir, but it stipulates here.
And you still want to serve the people of Bibb County, isn't that
Yes,
right?
sir. Yes, sir.
No further questions?
Agreed. Cross-examination. Mr. Rogers, thank you for being here today.
Yes, sir.
I'm just going to ask a few questions. we'll start by handing you a packet of information, okay? And the document you're holding in your hand, I'll represent to you as included within the packet that I've marked as Exhibit R2.
Yes,
It's been stipulated to, so I'm gonna hand that to you. And I'll ask you if you'll just look through there for just a second and see if in fact this document that you were holding is near the back of it.
the actual document that I did.
Yes, sir. It might be the second to last page, so I may have put you on a longer errand than I had
There
intended.
you go. That's right.
Thank you, sir. And of course, there's no dispute that you passed the background check.
Correct.
And there's no dispute that it wasn't done within the 3 business days of the
That is
qualifying
correct.
as required by law.
That's correct.
I want to ask you, if you will, to turn to the portion of that packet, it's more towards the front. It's entitled Affidavit for Sheriff. And take your time, I know I'm having to flip around.
Sure, no,
My
we do that.
apologies. It was like.
The declaration of candidacy and affidavit, or, okay, I got
That's it.
you. No, that's correct.
Yes.
Okay,
My apologies.
you're right.
Okay, Mr. Rush, let me just ask you a couple questions on this document. Turning to the second page. Is that your signature there on this document?
Yes, sir, it is.
All right, and it indicates you signed it on March 6th of 2024, is that correct?
That's correct.
And it indicates that Ms. Regina Evans, who works here at the Board of Elections, notarized that document.
That is correct.
And I'm going to ask you to turn back to the first page. Below your name and the date, it states, and I want you to know who agree with me, I hereby affirm that I meet the following qualifications for said office.
That is correct.
And then I'll skip to G,
Mm-hmm.
which says, I have been fingerprinted and a search made of local, state, and national fingerprint files to disclose any criminal record, which fingerprints were taken under the direction of the judge of the probate court and taken on or before, but no later than, the close of business on the 3rd day following the close of qualification for an election to the office of sheriff.
That's correct.
All right, now, obviously, you hadn't done it by then, and that's fine, right? Because it gives you an extra 3 days after qualifying.
That is correct.
But would you agree that that paragraph does in fact inform you of the requirement that within 3 business days at the end of qualifying, you go to the probate court? And get your- I'll take that document. Another question. Mr. Rogers, and this may seem out of the blue, okay, and I don't want to necessarily put your email address out there for everyone in the world, but do you have an email address that is rrogers56@cox.net?
Yes, I do.
Okay, so that's a valid email address.
Yes, it is.
And Mr. Rogers, did you take it upon yourself to investigate any further after you signed your affidavit, what other requirements there may be, other than what was told you in the affidavit? Did you go to the Secretary of State's website or anything like that to try to figure out what all the qualifications were?
Yes, I did.
And did you find in there any information indicating that you were to get fingerprinted for probate court?
Yes, I did.
And was that done, when was that, when did you do that?
That was actually after I went to my fingerprints done.
Okay, so then you found on the Secretary of State's website, the information indicating that you were supposed to do that.
Correct.
That's all I have. Thank you very much.
Okay.
Just 2 or 3 recalls. All right, Mr. Rogers. Now, when you left, you felt like you were qualified, is that right?
Yes, sir.
You called friends and family,
Yes,
told them you were qualified,
yes, sir.
said you were ready to go?
Yes, sir.
Now, had someone told you when you were there that you need to go over to the probate court, would you want over to the probate court?
Yes, sir.
And if that would have happened, if you would have gotten that nudge, would you in fact not be sitting here for this hearing today?
That's correct.
Okay, and you still want to serve the citizens of Bibb County?
That's right.
No further questions.
Nothing further for me.
Okay.
I have no questions for Mr. Rogers.
Everybody agree with this one, shut down?
I'm unclear if now is an appropriate time, but if I should be calling a witness, I can call Mr. Hughes.
I certainly have no objection to proceeding in that fashion.
Good afternoon, Mr. Hughes. If you would please, just start by stating your name for the record.
Marshall Hughes.
And, tell us a little about yourself. Do you have any law enforcement experience?
Yes, sir. I started at the Sheriff Department in 1995. I did 9.5 years at Bibb County Sheriff Department, stepped out on faith in Macon-Bibb in 2004. I did that for 18 years, and after COVID hit, I closed the shop down and I applied at the District Attorney's Office. I hired by Mr. Howard. I was there for 2 years, and I resigned in November to run for sheriff.
Understood. So, did I hear you were a deputy sheriff at one point?
Yes, sir. Originally with Bibb County Sheriff Department, Robert Johnson.
Understood. So you were a deputy sheriff here in Bibb County.
Yes, sir.
Did you say 9.5 years?
9.5 years.
And then, just to be sure I heard your testimony correct, that you're a business owner. You did that for 18 years after leaving the sheriff's office.
Yes, sir.
And then most recently, you were with the district attorney's office.
Yes, sir. As an investigator.
And you did that for about 2 years.
Yes, sir.
When did you resign?
November 23rd, I think. I think it was 23rd, 22nd or 23rd, 2023.
Do you have any fingerprinting requirements as part of your law enforcement
Yes, sir.
jobs?
Yes, sir.
So have you had your fingerprinting done before running for sheriff?
Yes, sir. I had got my fingerprint done once I got hired at the district attorney. Before I got hired at the district attorney's office, I had to go through that process before I was hired at the district attorney's office as an investigator.
And do they require you to keep those current?
Yes.
In case, for example, you committed a crime, it would then show up later on your fingerprints?
Yes, sir.
Can you tell us when most recently or how current your fingerprinting would have been before this election?
They do it every year, and every fiscal year, they do all fingerprints, not fingerprints, but they do a check, and also being post-certified, post, they also run a check on every post-certified officer throughout the year, make sure that everything is legitimate. They don't haven't committed any crime or have not reported. If they fail to report post-certification, they have a process in place that they are flagged any person that's post-certified if they commit any crime.
Is it fair to say that your fingerprints have been current as of the end of 2023?
Yes, sir.
Now, I am sure you have become aware that in the qualifications statute for sheriff, that you need to submit new fingerprints as part of that qualification. You aware of that?
No, yes, sir.
And did you do that?
At the time of qualifying, no, I didn't, but I did, once I was notified that Saturday, that Monday morning, and got my fingerprint done, background check done.
For sake of efficiency, I'm going to refer to the, I'll refer to this as a joint exhibit since we've stipulated to it. I don't know if we need to relabel it, but yes, the original document that was stipulated to, I'll call it a joint exhibit. Let me see if I can find the right page number.
For the record, I believe we'd be speaking about H2.
Oh, this is, okay. H2.
I know it's not on the copy.
I'm going to show you the joint exhibit for H2. The last page, do you recognize that document?
Yes, sir.
Tell us what that is.
This is from the probate court for fingerprint and everything was, fingerprints was submitted and came back called, no discrepancies.
Now, what's the date that was done?
March the 18th, 2024.
Is that 3 days after qualifying closed?
Yes, sir.
When were you notified that you had not provided fingerprints within that 3 days?
I was actually notified on Saturday from a civilian, and a civilian called me and was sharing with me that he overheard, he was told that 2 sheriff candidates failed to do their fingerprints. And when he told me that, I said, I didn't do my fingerprints. And at that point, I reached out to several people in the community, and that's how I found out.
Did you come to learn you needed to get those fingerprints done at the probate court?
Yes, sir.
Tell us about your Monday morning. What did you do?
Monday morning, I went down to the courthouse. I was there at 8 o'clock, went to probate court, and I spoke with the secretary there to ask if I can get my fingerprints done. She told me that the closing date had passed. So I left there and came over to the Board of Election office. I spoke with Mr. Tom Gillian, and me and him talked. He sent an email over to the probate judge and told her to allow me to get my fingerprints done. After leaving here, I got back over there about 9:10, 9:15. Went in, as I was entering, I ran into Mr. Ron Rogers. He was leaving out after getting his fingerprint done. And we talked briefly, and I went in and I spoke with the lady, and she actually allowed me to get my fingerprint done.
So you got yours done around 9:15, 9:30 Monday morning?
We got there at 9:40.
And you at least first actually learned on that Saturday?
Yes, sir.
I want to discuss another document. Again, this is Joint Exhibit H2. You can find the correct page. This is going to be 5 pages from the back, the affidavit for sheriff. Mr. Shady, can you please let us know if you recognize that document that I just handed you?
Yes, sir.
Can you tell us what that is, as you understand?
It's affidavit for sheriff.
Is that your handwriting that has filled out some of that document?
Yes, sir.
Turn the page to the next page. Is that your signature?
Yes, sir.
So you signed this when, during qualification?
Yes, sir, Monday morning.
When you say Monday morning, is that Monday, March 4th?
I'm sorry, it's March 4th, Monday.
So is that the first day of qualifying?
Yes, sir.
So you were there the very first day of qualifying?
Yes, sir. I was here at 9, I think on 9:40, I was the very first candidate to actually qualify. I was shit for sheriff.
Understood. And go back to that first page, please. Can you please look at subsection G there?
Yes, sir.
Now, I'm not gonna ask you to read that, but does that state that you need to get your fingerprinting done within the 3 days?
Yes, sir.
But you didn't do that, did you?
No, sir.
But you did, as soon as you found out, the very next Monday morning on March 18th.
Yes, sir.
I want to talk a little bit more about your qualifying. Now, were you confident that you had submitted everything that you needed to submit to qualify for sheriff when you were there?
Yes, sir.
What made you confident that you had given everything that was needed? Did you talk to anybody? Did you ask anybody anything?
Well, yes, sir. Mr. Tom Gillian, he's the supervisor, board supervisor, and by being a supervisor, he was the one that walked me through the process for doing my paperwork, and at the end, I asked him, is there anything I need to turn in, anything else I need to do? He said, no, only thing you need to do is, he said, only thing I need to do is, personal disclosure form, bring it back within 15 days after that.
Okay, now,
Excuse me, what was that last sentence you said?
I said, he told me, bring it back about 15 days later, bring back my personal disclosure form 15 days later.
All right, I'm sorry, I just want to make sure this is being said right. Thank you.
when you were speaking to Mr. Gillen during qualifying, did you have your paperwork that you were submitting that day with you?
No, sir, he gave it to me.
He gave that to you, okay.
Okay, sir.
And did you, were copies made, or did you leave a copy with the board, or excuse me, when you qualified?
Yes, after he notarized and I signed, I asked him, can I have a copy? He said yes, and at that point, we walked toward the copy machine. And that's when I asked him at that time, is there anything else I need to do? And that's when he made copies and gave me the form and said, turn the personal disclosure form back in 15 days, and nothing else I need to do. I was going to.
Okay, and the document that we just looked at, 2 documents back, this was the last page, joint exhibit H2. This is the probate court fingerprinting document that, that you said was dated March 18th.
Yes, sir.
Would that have been included in the documents that Mr. Gillen had when you were qualified?
No, sir.
Because you hadn't done your fingerprinting yet.
Correct.
And you asked Mr. Gillen if there was anything else that was needed, any other documentation. Is that right?
Anything I need to send me, that's correct.
And Mr. Gillen told you that all you needed to provide at this point was a personal financial disclosure form in 15 days.
Correct.
I want to talk about your background a little bit, and I want to be sure that I understand this. I know that there is no dispute, Mr. Hughes, that you possess all the attributes to be sheriff. But I want to go through them, and I want to confirm with you that that is in fact true.
Yes, sir.
Are you a United States citizen?
Yes, sir.
Have you been a resident of Bibb County for at least 2 years?
Yes, sir.
Are you a registered voter here in Bibb County?
Yes, sir.
Are you at least 25 years old?
Yes, sir.
Do you have a high school diploma?
Yes, sir.
Have you been convicted of a felony or any offense involving moral turpitude?
No, sir.
Did you file a complete written history of your places of residence for the past 6 years when you qualified?
Yes, sir.
Did you file a complete written history of your places of employment for the last 6 years when you qualified?
Yes, sir.
And are you a registered or certified peace officer?
Yes, sir.
And on top of all that, if I heard you correctly at the beginning of your testimony, you were a deputy sheriff here in Bibb County for 9.5 years,
Yes, sir.
and you had fingerprints current through at least December 2023, is that right?
Yes, sir.
And for the last 2 years, you've been an investigator for the district attorney.
Yes, sir.
And again, that's the district attorney for Bibb County.
Yes, sir.
I have no further questions for you. Mr. Nolan, counsel for the board, may have a couple questions.
Very briefly. Mr. Hughes, the form that Mr. Siegelman was talking about that's included within H2 from the probate court. You find that page?
Yes, sir.
That's an order of the probate court, isn't it?
Yes, sir.
And I believe you testified that that was not given to you in the packet of information, correct?
Correct.
But you didn't have to do anything with this form, did you?
When I went and picked it up from probate court and turned it into Mr. Gillen.
Okay, so you went and got this from the probate court and you brought it here.
Yes, sir.
Thank you. And I believe what you testified to earlier was that Mr. Gillen told you that what you had done was all you needed to provide to him, correct?
Yes, sir.
Is that how, I mean, you correct me if I'm wrong in the way I said it. Tell us what he said.
My question was to him specifically were, is there anything else I need to do or anything I need to turn in? And he said, no, you're qualified. And that's when he went into like a 15-day disclosure, personal disclosure.
Okay. And the 15-day personal disclosure was something that you had to generate and bring back.
No, that was in the folder that he gave to.
Right, but you did that and brought it back.
Yes, sir.
Because the probate court, you have to go down there and get your fingerprints and the judge signs it.
Correct.
And that was in G, which you signed that day, right?
Correct.
Did you take it upon yourself at any time to check the Secretary of State's website to see what the qualifications were for Sharon?
Yes, sir.
All right, did you do it afterwards, as Mr. Rogers said you did?
Pretty much.
Okay, so it was, and so you found the manual that tells you what the qualifications are for all the victims. And it says that you have to go and get your fingerprints at the probate court.
Yes, sir.
Thank you. That's all.
I got a couple, I got a few. Or if you want
Very brief redirect, and then Ms. Hughes, I just want to be very clear on one point. H2, joint exhibit. These are all they're stipulated to being your qualification paperwork.
Yes, sir.
Is that right?
Yes, sir.
Now, this stack of papers you gave to Mr. Gillum, or he had them at the time of your qualification. Am I understanding you correctly there?
Yes, sir.
But the probate court document was not in there, right? Because you hadn't gone to the court and provided it yet, right?
That's right.
So, said differently, the probate court fingerprinting form was missing from your qualifications paperwork at the time you were conversing with Mr. Gillum. Is that right?
That's right.
And you asked at that time, is there anything else that I need to provide to qualify?
That's correct.
You asked that of Mr. Gillum?
Yes, sir.
And he said no.
He said no.
Despite having your paperwork, this paperwork without the probate court fingerprinting document.
That's correct.
Okay. No further questions.
Took some mine, so only got. At the time, you were substantially qualified.
Yes,
That's
sir.
right. Now, if somebody would have been sitting there in that office and they would have told you to go down to the probate court, would you have done it?
Yes, sir.
And final question, you said you were the first, well, let's cut a couple questions in that. You said you were the first person to get qualified, right?
Yes, sir.
And at no point after that, did anybody give you a call and say, hey, I need you to go down to the probate court?
No, sir.
No further questions.
Mr. Hughes, now when we say that if someone would have told you, you would have gone down to the probate court, in fairness, you did sign a piece of paper that day that told you to go down to the probate court, didn't you?
Yes, sir.
All right.
If there's nothing further, I will excuse Mr. Hughes. At this time, I'll call Miss Regina Evans.
Nobody likes it.
Hey, Ms. Evans. My name is Joe Siegelman. I'm an attorney here representing Mr. Marshall Hughes, who's a candidate for sheriff. I am introducing myself because I'm not sure if you've been here the whole time to know who I am. I understood. Well, first, thank you for being here, and I understand this is not what anybody particularly likes to do, but if you would please, I do have a couple of questions. Will you state your name and also tell us what you do for work?
I'm Regina T. Evans, I'm County Correction Officer.
So thank you, and that's for the Macon-Bibb
Board of Elections.
Board of Elections. Thank you, and as part of those responsibilities, do you assist at all with the qualifying process or qualification of candidates?
Yes.
Can you tell us a little bit about what you do in that regard?
It depends on the party. If the Democratic Party is done with their candidate qualifying them. They bring them over to me and I put them in the system. And that's it.
Understood. Do you remember helping any candidates for sheriff in their qualifying?
I do.
Do you remember a candidate, DeAndre Hall, by any chance?
Yes.
Is that somebody you helped with their qualifying process?
I do. And not only I, it was also Charlotte Mann.
Understood. Okay, thank you. Do you happen to remember if you helped Mr. Hall on more than one day? Do you remember that?
Yes.
Can you tell us a little bit about your encounter on the first day when you first would have been helping him?
The Democratic Party, no, the Democratic Party didn't see him. He came to my office and he gave me his papers. I gave him the papers that I am supposed to give him. And I took his information in the system.
Understood. Do you happen to remember if Mr. Hall had fingerprints or a version of fingerprints within that first day?
No, he didn't.
He didn't have his fingerprints with him that day?
No.
Do you know whether or not you mentioned to him that he needed to get his fingerprints
I
done?
didn't mention that to him. It was Charlene.
Charlene, okay, who is Charlene?
Charlene, she's the executive assistant
For the Macon-Bibb County
for
Board?
the election. She's part-time.
Okay, so she's who told DeAndre Hall that he needed to get his fingerprinting done?
Yes.
Understood. And you said that you helped him twice, I think on 2 different days. So did he come back the next day?
I'm not familiar if he came back the next day, but I know he came back to bring his papers. That's when I helped him.
Understood. Okay, do you know if he had his fingerprints with him then?
He did.
He did. And so did he successfully qualify at that point? When he was with you, did you help him qualify?
Yes.
I don't think I have any more questions for you. Thank you very much.
I mean, just, first, I just want to say thank you for everything you do to make elections happen. But I really just want to ask, you did say that Charlene helped Mr. Hall?
Yes.
No further questions.
Just one second, Jay, I'm sorry. I don't want your moment in the spotlight to be over just yet.
For the record, I was ready to let you go.
All right, so, Regina, I'm gonna ask you just a few questions, and I need to sort of go through my paperwork here just a bit. A little bit out of sorts myself. I'm sorry. Okay, I'm gonna hand you a document that has been marked R4, okay? I'm gonna ask you if you recognize that document. If you will, please look at all 3 pages.
I recognize it.
Okay, can you tell us what that is, please, ma'am?
It was a reminder, well,
What is it generally? Is it an email?
Sorry?
Is it an email? generally?
yes, it's an email.
And who sent the email?
I sent the email,
All right, and on what day
February 6th,
of what year?
2024.
Okay, and the top page there gives an email address in the to line. What email address is that?
Okay, on the first one, the email address is Rogers, 56@cox.net.
Okay, and if you will, just turn to the second page, and what I want to ask you is if this is an identical email sent to a different address on the same day.
Yeah.
And what email address is that sent to?
Mr. Hughes for sheriff.
At
at gmail.com.
Okay, thank you. Now, you've already testified that these are identical emails, so would you mind reading what the email says?
Sure. Good morning. This is a reminder of what is needed for qualifying for sheriff. You will need to present the forms on the day you come to bring your qualifying fee. Please see attachment forms for qualifying fee. If you have any questions, please feel free to contact me at 478-621-6622.
Okay, and it's signed by you?
Yes.
All right. And if you wouldn't mind, could you just take a look at page 3, or the third page, I should say.
Yeah.
Was this document attached to both of these emails when they were sent out?
Yes.
All right. And what is this document say?
This document is the sheriff, the sheriff candidates must also present. It shows certification of state, of county, and be a probate for their fingerprint, criminal history, background, completion. And then it gives the code.
Okay. And if you look on the emails, you can just look at the first one, it's fine, right, that's cool. Where it says attachments. The first attachment there seems to be entitled Sheriff Candidates Must Also Present. Is that attachment?
Yes.
And was it attached to both of these emails?
Yes.
And on what day was it sent in?
February 6th.
And why did you send that out?
I wanted to remind all the candidates of the things that they need to have when qualifying came on March 4th.
Thank you very much. That's all I have.
I gotta go, I'm sorry. But I'm just trying to figure a couple things out. As we, your attorney, showed us that email. And I want you to take a look at this email address on your email right there. Would you read for me?
This email address
Yes,
is
ma'am.
rrogers66@cop.net.
Okay, thank you. Now, this is a email, let me first sheet, from the lawyer, when he wanted to contact Mr. Roberts. What email address is that?
Rogers was sheriff@gmail.com.
Okay. Here's a notice of this hearing today. Could you read what email address is right there?
Rogers or sheriff@gmail.com.
Okay, here's an email from the lawyer. He's contacting us about the hearing. What email is on that?
The same, Rogers or sheriff@gmail.com.
Okay. Now, if we go into my client's packet, where he's filling it out to be sheriff, could you tell us? That's his signature. Would you agree that's his signature right there? Mr. Roberts, if I said it was his signature, would you have any way to reason to disagree with me?
No.
Okay. And then could you tell me which email address he provided to the election office?
Rogers or sheriff@gmail.com.
Now, can we agree that the best email to reach the candidate at will be the email address that they provide to the county board of elections?
Not really, because when Mr. Rogers came in to fill out his COI, that is the email address that was on there that he had given me. So that's why I contacted him through that email address.
Okay, but this paperwork that he filled out to qualify shows the Roger the sheriff, right?
That was after.
Okay. Your lawyer has contacted him several times with that email address, is that right?
From what you showed me.
Okay. Do you have a copy of that deal?
I do.
Do you have a copy of it on you?
I have to go get it out.
Oh, okay. But I guess it's fair to say that, if somebody wants to contact you about official business, that they should probably contact you at the office, right? No further questions.
Okay. All of the documents. Ms. Thomas. Mr. Bay, you remember him ripping them off? Ripping them off? Ripping them off?
When did you get those documents?
I'm looking,
Were those the qualifying documents that he was ripping off?
no, it's showing March 20th.
Right, okay, correct. Thank you. What is the date of the email that we're talking about that you sent out to everyone? February 6th?
February 6th.
All right, and all of the documents that were ripped off of the page there were from March at the earliest, correct?
Right,
And you were just going off the email address you had, weren't you?
right. Well,
Were you standing out in the hall when I was talking to Mr. Rogers earlier when he was sitting up here? Did you happen to hear the questions I asked him? No, you didn't hear? Okay, well, we'll go back there, that's fine. Thank you, that's all I have.
Ms. Evans, I have no questions.
Okay.
With the board's indulgence and board's attorney's indulgence, there was some new testimony from Ms. Evans, for which the rebuttal comes from Mr. Hughes. May I recall Mr. Hughes for like 3 questions?
I'll no objection.
Okay. Mr. Hughes, I'm going to show you an email that appears to have been sent from Ms. Regina Evans, who works with the Macon County Board of Elections, to you on February 6th. That was just being discussed. Do you know if you received that email?
No, sir, I didn't.
Did you later find that email?
Yes, sir. I think hiring you, and talking to you, and then after talking to, that's just the end of the hall. You said that she sent out an email, and after we was talking, I looked through my spam, and that's what it was.
Okay, so you didn't see that email because it went to your spam?
Correct.
Did you provide the email address that she sent that email to?
No, sir.
And do you control what email addresses get directed to your spam?
I don't. No, sir.
Did you direct that emails from the Macon-Bibb County Board of Elections, did you set your email to send those emails to your spam?
No, sir.
Okay. And just to confirm, you never saw this email until after you and I spoke related to these proceedings, well after February 6th,
Yes, sir.
and after qualifying,
Yes, sir.
and after these proceedings have begun.
Yes, sir.
No further questions.
Nothing from me. May I take a point of privilege, just a moment? I'm not gonna make an argument. I think it sounds like it's gonna help everyone. I don't believe that any witness that has testified here getting to this point has been sworn. Virginia, you stay right there. I would propose that we swear them now retroactively, and any other witness who will testify going forward. May I do that?
Please. All right.
Would Mr. Rogers, Mr. Hughes, Virginia, would you please raise your hand? Do you swear or affirm that the testimony that you've given here today was the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. I think we have a lot of news for him. Thank you. I disappointed. I'll sit down and be quiet.
If I may, just very briefly confer with counsel for the board and sort of make sure that we are in the proceedings where we need to be, and just so we understand exactly what's next, if there are any witnesses.
Well, she's not here, you know she's not.
Yeah.
Okay. I didn't think she.
I'd like for it to be on the record that, and I know the council for the county will correct me, but for the record that, we as council for the candidates contemplated calling, Charlotte, what's her last name? Charlotte Manor, excuse me. But that she is not present and that there was testimony from Ms. Regina Evans that implicated her. We are not going to proceed with calling her because she's not here, but otherwise, would have called her. However, Ms. Evans testified to the best of her personal knowledge, of certain information, and, we believe that's sufficient for these purposes. But as part of the record, I want to make that clear.
I agree to the extent that we're talking about, is it okay for Regina to testify about what Charlotte said? I think that's, I don't have an objection. Thank you. At least one person sitting at this table, has requested a restroom break. Maybe take one from Mr. Chair.
Appreciate it. Forgive me, and this is a housekeeping matter, and may not be necessary by the juncture, but given that we're closing witness testimony, I also want to officially offer all of the exhibits that I previously handed out to the board as, how do we need to mark them, but as Q's exhibits individually, we can mark them specifically later. I just want to be sure that they're officially entered into the board record.
My idea would be that after we get together and make sure everything's in the pile, and whoever it needs to be in custody of will have.
Understood. Thank you. We called all the witnesses that we intend to call. We probably have some closing remarks, but we're,
So just to be clear, we're gonna take about a 10-minute break, and then when we come back, we'll be closing arguments. And then somebody at this table will call a question and we'll vote. Is that the procedure? So we're clear about what we're doing.
Yes, yes.
Was this one? Was this like?
But I just kept looking at my. Your blood sugar drops. That's literally what I've said. Exactly, exactly. And I ate on my hand. Yeah, because I saw it was. Oh, okay. Sorry, baby. But I was practicing time. And I know it broke down. Open fast enough, and he was moving so fast that he wouldn't have the base.
I did. That's not for everybody. You're right. She is Jewish.
I mean, it's good to have it, but I mean,
Mr. Nolan, do you need a water, juice, or anything?
Actually,
Would you mind handing me that?
just water.
How did you know that's what I was thinking? I was almost done with mine. Thank you so
Can't go now. Yeah.
I'm using it.
You got, they keep, like, Sunday, they get a picture, where you can get something. You got to get it vote.
All right, everybody, it's time, let's get going.
We need a court order, it'll be ready.
We have one.
With all these cameras there, you think we. Wait, let's all hear from the report. Whenever you're ready. Mr. Chair, I'm gonna just go ahead and give my argument now and then allow the other side to give the vote solution. And I will try to address all of the arguments, obviously. And I'll first say lawyers do not like it when the opposing counsel compliments them in their summation. So as I thank Mr. Berry and Mr. Siegler for being here and telling you all, as you can tell, what great lawyers they are not like it. But they are. We all saw that. We all saw the argument and heard the argument that they made, which I think was very good. However, there are a couple things that jump out. First is, I completely agree with Mr. Siegelman that what we should all be here doing as lawyers, and we are, and they are, is try to help you get it right. Mr. Siegelman said that. It's absolutely correct. We just want to get it right. Why? Well, because the citizens of Bibb County deserve it, obviously. But so do these two gentlemen. These are, and I want to say this only because I don't want it to appear that I'm being critical of them personally as I argue. These are clearly fine citizens of Bibb County, fine gentlemen, law enforcement officers, public servants. They serve, they protect, they've done all those things. And let me say one thing other. They're also, the lawyers are correct. There is no dispute as to whether they passed the background check. Okay. Qualifying in on the 8th. I absolutely believe, and that they found out over the weekend sometime after qualifying, or after the week after, somewhere the weekend before the 18th, and as soon Monday morning as they could, they were down there getting their fingerprints. Okay, it's just not within the deadline. So, and they passed those background checks and they came back. But we do need to talk about the law, because it's been talked about a lot before we got into testimony, and I want to address a few things. In regard to 15-16-1, you'll recall the argument being made about the various sections of C. So C1, C2, and C3. And you'll remember about the transit property, which I appreciate, which is something that we all use to argue sports with each other, those of us who do that sort of thing. But it's absolutely what it is, transit property. Okay, but here's where I disagree. First, C1 does not equal C2. And that's where it falls. Because everything else was dependent on that. So what you'll recall is that the Grogan case talked about its ruling applying, and let me get the language right. Grogan says, we hold the deadlines stated in C1G and C2 are applicable to a person seeking by primary election his party's nomination as candidate for the office of county sheriff. It didn't say they were the same thing. They didn't say that. They said they both apply to a particular situation. It's different. So that's I don't want to go too far with it, but that's where it starts to sort of turn. The other thing, and I do want to just talk for a second about C1 and C2 and C3 and tell you why they're different. Here's the difference, and it's always been this way. C1 starts by saying, no person shall be eligible to hold the office of sheriff unless such person. Hold on. When you get to G, we all know what G says. I'm not going to read these. Two begins, each person offering his or her candidacy of the office of sheriff shall at the time, et cetera, et cetera, et cetera. Right? Three same. But why we're here, and Mr. Siegel would say, I don't want to be the horse here, but what we're talking about is no person shall be eligible to hold the office of sheriff unless such person is fingerprinted, et cetera, by the purpose. So 100 out of 100 lawyers would read that the same way. And the thing about statutory construction, and I don't want to belabor the point, but it's hard when somebody makes such a good legal argument not to present the other side of it. The thing about statutory construction is, if the language is clear, if what we call the plain language is clear, dead stop, no interpretation. That's one of the primary rules of statutory construction. You're not qualified unless you have done these things. Now then, a lot of the rest of the argument dealt with these cases in Muskogee in 16 and Cobb in 20, right? Those are opinions issued by superior courts that were not appealed, for one thing. So they're not binding on us. I suppose you're bound by the Superior Court of Bibb County in some way, but Georgia appellate opinions are binding on the rest of the court system, right, as it flows down. But you're not bound by what Muskogee or Cobb County said, even if you were. Okay, let's say that these lawyers get up and say, no, we're wrong. You are bound by it. They interpret it secretly, right? Not C1. C1's the only one that is that way. So they are different in that way. Again, C1 doesn't equal C2, doesn't equal C2. That's where it falls from. From C1 to C2. That's where the argument goes. Now, there has been a Georgia Supreme Court case that talked about qualifications, procedural qualifications, that kind of thing. And the interesting thing about that case is that it's from 2022. And that case is entitled Camp versus Williams, 314 Georgia 699. And it didn't deal with this exact C1G, 1561 C1G. That's not what they were dealing with. But the language that they use in their holding absolutely covers this case and absolutely transfers this case. Not only was it the Georgia Supreme Court, but it was 2 years after Cobb, 6 years after Liscott, right? And so here's just a portion of that opinion. In short, our conclusion that the qualifications referenced in OCGA 21-2-6 includes both the legally specified prerequisites for holding office and the procedural requirements necessary to seek office fits comfortably within the overall usage of that and related terms throughout the Elections Code. Thus, OCGA 21-2-6's reference to the qualifications for seeking and holding office is best read to include all prerequisites, including the procedural requirements to seek office, not just the traits required to hold it. You've heard that today, the traits, the substance, right? It includes the procedure too. And I will say that I don't take any joy in that. I may get a little competitive as a lawyer, this is my job. I take no joy in saying that. But it's true. It's the law. And 21-2-6, of course, is the statute that brings us here today, which was talked a little bit about in opposing counsel's argument, which allows within 14 days after qualifying, right, any elector can challenge the qualifications of any candidate. But the superintendent, which is the five of you, can do it anytime, right? Do it anytime. No, we've done it. We do it when we think we have to, right? We do it because we don't do it because we're not trying to allow candidates to serve. We do it because if you allow a candidate to be on the ballot and to affect an election or win an election, it's subject to challenge afterwards, right? Better handle that. Better handle that. The people that work in this office, Tom, Virginia, Charlene, the rest. I think the record showed they're trying to help everybody. That's what I heard. Sent out an email in February. The thing about Mr. Rogers' email was that, I don't know if you all remember, Regina did, I don't think she was wanting to be in here with all the cameras, which you don't believe, but she wasn't in here when we talked about it. But what I asked him was, is this a valid email address for you? And I'm sure everybody's wondering why in the world I was asking him that. He said yes. And she said he gave it to her. And I'm not testing this further, but Mr. Rogers is a wonderful man. I've met him. I don't know if you don't either. I mean, no one here wishes anything to against his candidates, but this is what we have to do, right? This is what we have to do, is make hard decisions. And when the statute requires, as this one does, that no person shall be eligible to hold office of sheriff unless such person is fingerprinted by the probate court. You know, we may want to let these guys in the race. I don't know, I don't presume to know anybody's personal opinions about it. But we have to make a hard decision. That's what you have to do. You have to get it right. And I think what you heard earlier was that rather than a substantive qualification, this was just a procedural misstep on the part of these two gentlemen, and it was. And Camp says that's part of the qualifications. That's part of what has to be considered and has to be done, and whether anybody wants to do it or not. I don't really think I'm going to say much else, but I do want to say, look, everybody has done this. All right, it's on the Secretary of State's website. It's in the affidavit every time. It's in the email that Regina sent. And I think most importantly, it's in that affidavit that it was signed. So it's hard to say that, well, why didn't you tell me? But it's in there. It's in there. And are the conversations with each person that comes into this office that talks to 3 different people gonna be verbatim? No. Right? But the law applies to everyone. Everyone's responsible for nothing. When you run for office, you're responsible for nothing. You just are. And again, I can't stress enough that it is in the affidavit. It's in the affidavit. And the board's gonna vote. And however the board votes, it'll be accepted or it'll be favorable, or whatever it'll be. But, that's it. Now, I'm about to sit down, and here's the thing about me sitting down and me sort of ceding any last word I might have to opposing counsel. It's terrible. All right, I'm gonna sit here and I'm gonna cringe and I'm gonna want to say something and I'm not gonna be able to. Okay? So I just hope that, I think everybody heard the evidence, everybody's heard the arguments, everybody understands it. And I'm just going to sit here quietly with my thoughts. So thank you all.
It doesn't matter really where I present. First off, thank you. Sincerely, thank you. You have given an opportunity for Mr. Hughes and Mr. Rogers to be heard. You know, we feel strongly about our position. I'm sure you can tell. We believe that we've given you the tools to make the decision to find that Mr. Hughes and indeed Mr. Rogers are indeed qualified and shouldn't have been handed out. After counsel for the board's comments, I do have several remarks in that regard. I want to be very clear. I'm actually personally quite familiar with the 2022 case that you mentioned because I was one of the attorneys that argued it before the Supreme Court. So I know what case he's talking about, and I will tell you that I don't think it's applicable here. Otherwise, we would have mentioned it. And I will tell you exactly why I think that. First, this case, it's called Campy Williams, involved a candidate who did not qualify at all. Didn't qualify at all. He was a candidate who was substituted for another candidate who had been disqualified. So you're talking about a Supreme Court case, not interpreting a situation like here where you have a candidate who was actually qualified. Through the qualifications process, you have a candidate that was plucked to replace a candidate who had qualified but then was later disqualified. It is an entirely different situation. And I wanna hone in on one, we'll go back to this. But I want to hone in on one particular word from that case that counsel for the county stated. Procedural prerequisite. Hopefully I spelled that right. We're not here about prerequisites. We're here about a candidate who substantively is qualified. Everybody agrees. We're here about a dangling post-qualification procedure. And for that reason, I don't think the board should take into consideration, or to the extent you do take into consideration this newest case, it doesn't impact the situation here. Finally, I agree with counsel for the county in that he said if a statute is clear, then that's what it is. And I started out by saying, if you ask 100 of 100 attorneys what their interpretation of this is, you're probably going to get the same answer because you don't have courts that have interpreted that. But guess what? Courts are tasked with determining how they should interpret the statute. And in this case, we have two courts that have done that, 2016 and 2020. Now, he's also right. I want to commend him, but this is a different county. Muskogee is a Bibb county. Cobb County is a Bibb county. The cases weren't appealed. If they were appealed to the appellate court, then it would be very clear. It has to be followed. That's not what happened here. So Bibb County could go out on an island and do something different than two other counties have done. That would be, in my view, contrary to what the status of the law currently is. And there's another element of statutory interpretation and frankly case law interpretation that I think is important. Cases are to be read consistent with one another whenever possible. In other words, this 2022 case should be read as consistent with the 1980 case, unless it's explicitly overturned law, which happens, it does happen, but otherwise, these cases should be read consistently with one another. The cases in 2016 in Muskogee and 2020 in Cobb County, I'll give the board those citations so that it's clear in the record that those are before you. But those should be read as consistent with Supreme Court precedent and the law of the state. And in fact, that's part of, I'm not there yet, but I think in order for this board to actually hold that Mr. Hughes, indeed Mr. Rogers, are not qualified, is to actually make a decision that is inconsistent with the Supreme Court precedent that is applicable, or it would be inconsistent with the two Superior Court cases that actually have heard this issue. Now, counsel for the county said C1 does not equal C2, and therefore doesn't equal C3. I disagree. So I'm going to refer back to, and I know we haven't yet marked these, but the very first of the Hughes exhibits that I gave you was a copy of the Supreme Court case from 1980. This is Grogan versus Paulding County. Now I highlighted a small provision. Counsel for Mr. Rogers, I'll call him co-counsel, did say that this is a relatively simple case, and in a lot of ways it is. It's not linear, but that doesn't mean it's not necessarily simple. I highlighted this portion because I felt that it was the easiest way to get to where we needed to get the explanation. But it's not the entire case. You'll see that there's highlighting on the second page that I'll go over in a minute. But if you look to the very first paragraph, and indeed the very first sentence under number 1 on the left side, it says the trial court held that Grogan failed to meet the requirements of Code Annotated 24-2801 C1G and C2. Okay, it's not just in this one little paragraph up here. It talks about how this person was disqualified pursuant to C1G and C2. And then if you go to just the language underneath where I highlighted, it says accordingly the trial court did not err. Meaning that the trial court ruling with regard to C1G and C2 is held up by the Supreme Court. So we can't just say, okay, the court didn't consider C2 or didn't believe that C2 applied because the case law says that it applied. And now the preceding language, I will admit to you, is different. The introductory language of C1 and the introductory language of C2 is different. I'm now looking at the second exhibit that I gave you. This is the historical statute, would have been the statute that the Supreme Court in the case we just looked at would have actually considered. So there's a subsection C that's titled Qualifications, right? And the Supreme Court held that everything under qualifications has to be done to be qualified. That's what the Grogan holding essentially is. In Grogan, somebody didn't qualify, didn't didn't have everything pursuant to C1G, which is why we're here, but also C2. And both of those, again, not to rehash this entirely, but again, both of those, C1G and C2, state that they need to be done at the time such person qualifies, and by the close of qualification. Now, the language is different. The C1 says no person shall be eligible to hold the office of sheriff unless. C2 says each person offering his or her candidacy for the office of sheriff shall. So the language is admittedly different. But did that matter to the Supreme Court? No, the Supreme Court said C2 matters just as much as C1. You gotta do it. And it says, right here, plain as day, and C2, and C2. The trial court did not err. And the trial court ruled regarding C1G and C2. Now, this is oversimplification. This should be C1G. C1G is the only post-qualification dangling requirement. None of the other subsections of C1 have that requirement. So in that sense, it's C1G that equals C2. Okay? So we're only here about C1G, and to make things simple, I said C1. The substantive qualifications that we went over that are quite material, Mr. Hughes and Mr. Rogers testified to no dispute that they have those attributes. Those are elsewhere in C1. But in C1G, it has this dangling requirement and this post-qualification procedural element that exists in C2 and exists in C3. I wish that there was case law directly on point regarding C1, C1G specifically, but there isn't. But we do have case law on C3, and for the reasons I just gave, C1G does equal, as far as that dangling requirement, C2. C1G is fingerprinting, C2 is affidavit, C3 is another affidavit. So these are different in that sense, but they all have this post-qualification dangling 3-day requirement. The Supreme Court says C1 equals C2. I think that's plain as day. You have the case in front of you, and I think you will agree. The Georgia legislature, and another exhibit I've shown you, use the exact same language for C3 as it did for C2. So there's no dispute there. We know C2 equals C3. We have case law interpreting a candidate who did not meet the 3-day requirement under C3 and said, you can't remove them from the ballot. Happened in 2006 in Muskogee County, happened again in 2020 in Cobb County. There's been no case inconsistent with that. This 2022 case involving a candidate that didn't even qualify is not applicable here. And to the extent it has any bearing, it's talking about procedural prerequisites, not these post-qualification dangling requirements that exist in this particular sheriff qualification. It was a judicial qualification, by the way. It was different in that other case. So what does this board have to do to rule that these gentlemen should be off the ballot? You have to do one of two things. You have to say, as counsel for the county said, C1 doesn't equal C2 and therefore doesn't equal C3. In 2016 and 2020, it was something different. You know, might have been the same 3-day requirement. The Supreme Court might have said it's just as important. C1 is just as important as C2 or vice versa, but you'll have to say that that is not the meaning of that case, or you will have to issue a decision that is inconsistent with that Supreme Court case. So that's the first option, is say, I'll just do this, Supreme Court. You have to say no to the Supreme Court's only case in this matter. Or you have to say that in 2016, I won't try to spell Muskogee.
You went to Alabama, and I'll forgive you.
Oh, and now we've already lost.
You just felt boy. I was Auburn, so you know what I'm doing.
So you either have to say no to what the Supreme Court said, or you have to say these courts got it wrong. You can do that, but you need to know what you're doing. You're either going to say that the Supreme Court did not say that these provisions were equivalent as far as them being required for qualification, or you're saying that these two courts, the only two that have heard this before, both of them got it wrong. I don't think that that is the position that this board wants to take today. I just don't think that it is. Now, in the Grogan case, again, this is the only case that touched on this exact issue. Once again, this is first exhibit by Hughes. The court, when it issued its decision, said, although we are disqualifying pursuant to C1 and C1G and C2, which again have changed, right? The law that exists today is different than the law that this court interpreted. They took issue with a couple points. They took issue with 2 points, precisely. They said, in this case before us, there is no evidence that candidates running for the same office were treated any differently. That's established by that court decision. No difference in the treatment of the candidates, provided the same information. The other point in that case was the court made very clear that the candidate who was disqualified, he didn't ask. He did not ask. He could have asked. The Supreme Court says he testified 3 times that he did not ask whether there were other qualification requirements in addition to filling out the form and paying the fee. This person, Grogan, made no specific request for any further information as to the qualifications of the office of sheriff. That's the opposite of the testimony that we've got today. It also says there's no evidence that this candidate was treated any differently, provided any different information. That's different. You heard from Ms. Regina Evans, and I am not faulting any person working for the Board of Elections. I know the work is important. I know there is no way that the information provided can be verbatim, but it should be consistent. It's not only inconsistent, it is, I'll explain. So you have I'm not gonna have enough room on this board, but hopefully you can see this. This column is for the candidates. Did they ask if they needed to do anything else, or didn't they ask? Here, were they provided accurate information, were they given no information, or were they given wrong information? Okay, we have testimony that you have DeAndre Hall. This is who Shirley Maynard and Regina Evans helped. Didn't ask, didn't have his fingerprints, but they said, they told him you need your fingerprints. He went and got his fingerprints. He qualified. He's not here today because he got the information, even though he didn't ask. You have Mr. Rogers. He didn't ask, but he wasn't given any information. Different column, different situation. Then you have somebody, Mr. Hughes, he asked. Just like they talk about in this case that I gave you. He asked, but then he's given the wrong information. Now, I'm not trying to fault anybody with the board. I promise you, I know that this is tough work. We appreciate the service that's provided. But these are all different situations, and they matter. They really matter. you've got somebody who's not here today because they got the information from someone at the board and they didn't even ask. And yet we have somebody sitting here who did ask, got the wrong information. And now he's subject to disqualification. That's not fair. That's not fair. I'm going to show you what's been previously marked as an exhibit. I actually think I've lost my copy. This is 2126. So it'll look just like this, but it'll be for 2126. This information is not highlighted because I'll be honest, I wasn't sure what information was going to come out of this hearing, but it is important. The last subsection, I'm familiar enough where I can refer to it even though I don't have a copy. The last subsection talks about the Superior Court's review, and you'll see that one reason for reversal of a board's decision, irrespective of the actual state of the law that we've already gone over at some length, is that there is an unlawful procedure. That's what the Supreme Court of Rogan was referring to when it talks about treating candidates differently. If they're treated differently, that's a reason for reversal. And we have that here. I don't believe that we need to go there. I really don't. I don't think we do. I am sincere. Not that you need to be sincere. This is not something I made up. This is not crafty lawyering. This is that case, the Grogan case. They're the ones, they're the ones, not me, they're the ones that said, we consider C2 of equal importance to C1G. Trial court held that, we affirmed the trial court, done. Supreme Court said that. C1 equals C2. C3 didn't exist at the time. We've got the legislature, they come in 2013, they added C3, exact same language as C2. Supreme Court's already said, the introductory language of C1 and C2 didn't change with this legislative change. This isn't necessary, but I'm going to show you anyway, just because it's that straightforward and simple. I've already given you the legislative change. Yeah, it seems to have misplaced my copy, but I'm going to show you. This is 1516.1. Okay, this is just purely the statute that we're here about today. And you don't need a copy because it's the entire reason we're here. I'm going to give you this just enough to it's easier. There's my 21.2. Okay. So this is the statute that we're here for today. Now, I want you to look at what I've handed you, but I also want you to look at the legislative change. It's going to look like this. I want you to look at the first page. And it says, qualifications, no person shall be eligible to hold office of sheriff unless such person meets those requirements. If it was changed, there'd be a line through it. That's how the legislature crosses through. And then if there was language added, it would be underlined. If you turn to the next page, you can see that. So there's no change to C1. If you look at C2, this is on the third page. This part is actually highlighted. You can see the legislature specifically left that opening language the same. Each person offering his or her candidacy for the office of sheriff shall. They cross out the language after that, but they leave that introductory language, which is the exact language that existed in 1980 that the court considered. So that language hasn't changed, and that's why C1 and C2 are still equal, because the legislature left that untouched. So this gets me back to the points that we talked about at the beginning. This is from 1936, but this is state Supreme Court law. Statutes which limit an individual's right to hold office must be construed broadly in favor of those seeking office. What did the courts in 2016 and 2020 do in Muskogee and Cobb County? They followed that. This is from the Muskogee County case. They held that failure to submit the affidavit required by subsection C3 within 3 days, failure to do that within 3 days was not disqualifying. Kept Donna Tompkins on the ballot. She won. She was sheriff for 4 years. This is still from the Muskogee ruling. The same thing. Words limiting the right of a person to hold office are to be given a liberal construction in favor of those seeking to hold office. That's what they did in 2016 and in 2020. The superior courts said, no, we don't think that these dangling post-qualification time periods can keep somebody off the ballot. Both courts ruled the same thing consistently. I'm only going to hold this up for a second because I don't think it's as important, but basically what this says is, even when you think the law is clear, even when the language is clear, we want to give effect to the intention of the legislature, and courts are not controlled by the literal meaning of the statute. The courts, not our own interpretations, they're the ones who determine the meaning of the statute. And you have an interpretation of C3 2 times since this new law was enacted. And finally, the decision wasn't close. The superior courts, now this is from 2016, again from the Muskogee case, but it wasn't close. Clearly erroneous, arbitrary, unwarranted exercise of discretion. Actually said it's in violation of law. We're not talking about some super close legal question. I mean, basically, if you want to disregard this, you're basically saying that this 2022 Supreme Court case overrules and reverses these 2 earlier cases. But that's not the way it goes. 1, I don't think it's applicable at all. And 2, even if it had some bearing, cases are to be read consistent with one another. A judicial candidate who did not qualify at all, there was an issue in this other case, the Supreme Court case, is not equivalent to a sheriff who actually did qualify, sheriff candidate who actually did qualify. So I have talked long enough, but it is undisputed, that this man has the attributes that we want in a sheriff, that he meets every one of the substantive qualifications, and more than that. And I know, counsel for the county, for the board said this, and I appreciate it, but it bears repeating. This is not just some law-abiding citizen. This is a servant of the county. This is someone who served, make sure I tell you correctly, he served for 9.5 years as deputy sheriff. And then most recently as an investigator for the DA. This is the kind of candidate you want. I know co-counsel is going to have comments, but I'm going to leave with this. You want the people to choose. And the interpretation of the law should be consistent with giving the people choice. And that's exactly what happened in the 2 cases interpreting subsection C3 in 2016 and 2020. Before I sit down, I'm going to give the board those case citations in case there's any desire to reference those. I mentioned this earlier, and the offer stands that to the extent the board does wish to withhold ruling today and seek a legal brief for further information on this legal issue to ensure that you get it right if there is any doubt today, that offer still stands as well. But at a minimum, we want to give you these citations. This is Donna Tompkins versus Muskogee County Board of Elections, SU 16 CV 1360. And that's the 2016 case. And Craig Owens versus Brown County Board of Elections, case number 20-1-2203. That's the 2020 case. Thank you again for all your time and attention, and for the duty that all of you serve as members of this board. Thank you for your consideration. Thank you for your determination to get this right, and I thank you for giving us this opportunity to try to help you do that. Thank you.
So I'll prep some of these really quickly, so I don't have to take up too much. Try to move through them quickly as I can. First of all, on behalf of myself and my client, I want to thank you all for coming in today. If there's anything I've done, if I've talked too fast, if I ripped up too many papers, I want to honestly and wholeheartedly apologize. I'm passionate about this because it's really important. My client is a good person. He served his community as an officer. He served his community as a teacher. He served his community. I met him doing community service in the community. He's that type of person. I thank you, Mr. Nolan. Did an amazing job. I think you are an excellent lawyer, and I think you argue this just as I think you should have. And when I say that, I think, given the cases and everything that is there, I think the only argument to say is that it's just plain and it's there and it didn't happen and we got to disqualify. If I was on that side, that's probably what I would say. But you know, I'm not. And I do spend quite a bit of time up at the Capitol, probably the better part of my career, interpreting some of this stuff. And that's both in Georgia and that's in DC. But here locally, I'm there most days when we're in session. And most recently, I was there on Sunday Dive till about 2 in the morning, looking at bills, trying to make sure that organizations and legislators got it right. And here's what I've learned. Here's what I've come to know. It's never quite so clear. And quite honestly, if it was quite so clear, you wouldn't need folks like us. We wouldn't need lawyers. We wouldn't need judges. We would just skim through it and we'd say, hey, that's the decision. But what happens is, as time evolves, the legislation evolves, and it evolves through the legislators correcting things that they see wrong, and it evolves through cases. And that's what we've seen here. I'll call them breadcrumbs. Those breadcrumbs have been dropped throughout, and you've heard them throughout this case. If it was just that clear, and that's all there was, then, well, in 1980, we wouldn't have gotten that case where we said C1 is equal to C2. Wouldn't happen. If it was just that simple, we wouldn't have gotten to 2013 where we have this change in the law. That happens because the legislators make that decision. And that's where we get C3. And that's how C3 is like C2. So I know council spend a bit of time, and it is kind of funny that we're looking at math, all as adults here, trying to figure it out. I'm sure some of Mr. Rogers' students could figure that equation out a lot quicker than we could. But for this part, it is simple. If C1 is equal to C2, C2 is equal to C3, then C1 is in fact equal to C3. We can't ignore that. But what's more important is not just that we can't ignore that, it's that the courts did not ignore that when they made their decisions. Now, one thing I would probably disagree with Mr. Nolan on, and he said, well, there's no court of appeals case here that would say what needs to happen. So we can't use that as a guide. Well, we can't, but when you look at interpreting the law, it's not just, do we have a Supreme Court of the United States case? No, we don't. Do we have something federally? No. Do we have something, the Supreme Court? No. Do we have something in the Court of Appeals? No. But do we have something that is binding where this has been decided before? Oh, we do. Here come our breadcrumbs. That's where the Muskogee County case makes a difference. That's where the Cobb County case makes a difference, because this has been decided. I mean, and when you read an opinion, there's no doubt what they're saying here. Words limiting the rights of a person to hold office are given a liberal construction in favor of the person that's seeking to hold office. That's a message. Statutes that limit an individual's right to hold office are to be construed broadly in favor of those seeking office. Those are the things that judges look at when they're trying to make decisions. And now, when we look at some of this other stuff, and we talk about what the legislators mean, the effect of the intention of the legislators is that courts are not controlled by the literal meaning. The only way you get to a decision against this client, the only way you go against the court decisions and the legislation that's out there is to take a literal meaning. But the court's already told you, courts are not controlled by the literal meaning of the statute. That's how we got to here. C1 is equal to C2, and C2 is equal to C3. They're the same key that leaves the people on the ballot. That opened up clause 3 is also the same one that opens up clause 2 and clause 1. And that's what's happening right here. And that's what the courts in Muskogee County and in Cobb County decided. Mr. Nolan brought up a very good point. We don't have an appellate opinion on that. You know why? Folks don't appeal when somebody gets it right. And I'm asking you all today, please take the time, look at this, and get it right. Now we'll paint a different picture. And I'll leave you with this. Nope. I can't paint it with the wrong board. This isn't that opinion on what they said. The decision of the superintendent and the board to disqualify the appellant. This is spot on. And the only case that really speaks to it, because remember the Cobb County case doesn't have an opinion in the same way. So this is the only one that speaks to it. They said that they were clearly erroneous in the view of reliable and probative substantive evidence on the whole record, and that it was arbitrary in a clearly unwarranted exercise of discretion and in violation of the laws of the state. Now I'm going to say this. I'm not asking you to do something new. I'm not asking you all to go against the law. I want you to do what is the law, and I want you to follow that. And I would like for my client and Mr. Hughes to be back on the ballot for the citizens of Bibb County to make a decision on whether or not they should serve as sheriff. Thank you.
Don't worry, I'm not arguing. I do think, Mr. Chair, I'll switch back to council board. I do think it is appropriate to call the question and allow the board to vote, and then we can reduce whatever decision is made to writing. I've given, I think, you a form for each case you have that allows for either decision.
Mr. Chairman, if I might, I'm mindful that whatever we decide here, whatever we say in these proceedings is likely to be examined by a court in the future, so we need to be careful with our words. But I'm also mindful that this is a public body, and I think we owe the public and these potential candidates not only a decision, but also some substance, some accounting of our reasoning. So I would certainly appreciate the chance to hear from my colleagues. I would hope that I could perhaps have some things to say as well before we vote, because I think that we deserve to hear from each other. All right, well, I'll certainly, any or all of my
First of all,
colleagues.
I'll call the question. Now we go into
So I was the one who made the motion several weeks ago to begin these proceedings, because at that time, we had two candidates who had not provided fingerprints or background checks. And we had to act at that time in order to preserve this board's latitude to act. That was absolutely necessary. But I also looked at, beyond that, I think it's absolutely true that these candidates were offered adequate notice. Even if they did not get the email, they certainly did receive and sign these affidavits referencing the statute in question. Whether people of Bibb County should take that inattention into detail into account, perhaps they should. But I think that they should have that opportunity if that's possible. And I'm also mindful, if we look at the statute, that we don't have to merely guess at what the legislature's intent was. We are given a statement of intent at the beginning there, and we're given a list of things that are necessary for somebody to be qualified for office. And when we made our decision to call this hearing some weeks ago, some of those qualifications were not met. There were no fingerprints, there were no background checks. And if that were the case today, then I would say absolutely we must disqualify these candidates. Those qualifications, though they were provided belatedly, they were provided. And I certainly look at the body of case law and think that the correct decision for us as a board is to leave these candidates on the ballot and to let the people of Bibb County decide whether in fact they should serve as sheriff. Thank you, Mr. Chairman.
Any further discussion?
Go ahead, Kim.
I concur with my counterpart. My question to us as a board and to us as the Board of Elections, what can we do? Although everyone here is old enough, reading is fundamental, I would cite someone that I know that recently qualified for an office, left off a document, and within 30 minutes, the person was called to make sure that the proper documentation was done. Again, the qualifications were met, although they were not met within that 3-day period. What I'm hearing is, as soon as the candidates were notified, they went to do what they were supposed to do. So I say, since they were met, these candidates should be allowed to stay on. However, we as a board, as a Democratic Party or Republican Party or whoever's accepting funds, we need to be educated, and then if they're going to qualify with us, and then once the packets are turned in, someone needs to examine the packets. Because we need to always inspect what we expect.
Yeah, I want to say a few words. First of all, I know these gentlemen personally, and there's not a doubt in my mind that either one of them will make a fine sheriff on me. However, in my opinion, rules are rules. There's no exception. In this affidavit you signed, there's one exemption. Not even a current sheriff is exempt from that. Not one sheriff is exempt from the fingerprint requirement. That's what it says in the affidavit. You signed that affidavit. You signed an affidavit that said that you had done it or you were going to do it. I'm not involved with all the courts. I understand. And you have the right to, I assume, appeal this to a higher land dispute court. My opinion is that you signed a document, you knew what you were signing. When I turned in my homework, like my teacher said, thank you very much, you still get it down. Rules are rules, I'm sorry. But my opinion is, I'm gonna vote for these gentlemen to be disqualified, simply because, not the quality of the person, but there were certain things they were supposed to do. And as a sheriff, it's the only qualification requirement, I believe, is the sheriff. And if we let it go 3 days, and add that 3 days to give people even more time, in my opinion, maybe you're right about that, I'm not in the legislature every day. However, it wasn't done. Everybody else, and how fair is that to the other candidates that are in it? I don't know if we should discuss that. How fair is it to the candidates that did what they were supposed to do? I don't know if that's part of anybody's decision or not. I just know what it says in that affidavit, and I know that everybody that knows me, all I want to do is the right thing. And for me, the right thing is to disqualify these gentlemen because they didn't do what they were supposed to do. If you don't like our decision on what I think, I don't know how everybody else is going to vote, we have the ability to appeal this to the Superior Court. They're the final arbiter that will make this decision. Does C equal 2 or 3 or 1? And I'm sorry, but I wrote a lot of notes. I came here with an open mind, and I really did. But these gentlemen were sent emails, and I'm sorry you didn't get them. But that's my decision.
I'll call for the question. I'm gonna make a comment real quick. I find it troubling myself. Gentlemen, you are fine people. I'm not disputing that, but you signed an affidavit. You're running for sheriff. You can fulfill that affidavit. That's what it said.
So make sure you explain the vote. Yes, is one way. No is that. And we have to do it individually. If I'm not mistaken, right?
You need to do a roll?
Yes, please,
Okay.
please.
The question is the candidate qualified to hold the office of sheriff for Bibb County? An affirmative vote means qualified. A negative vote means disqualified.
As to, which candidate first?
Which person? Oh, okay. I didn't get that. Marshall Hughes.
I vote no.
You vote to not qualified, disqualified.
Sure, it might be easier if you just call for affirmative votes of qualified, followed by.
Affirmative to qualify?
Yes.
Yes.
Negative to not qualify.
Negative, no, well.
For Ronald Rogers. Affirmative to qualify,
Yes.
Yes.
a negative to not qualify.
Negative.
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 Mr. Chair, just sign those, those decisions, we'll make copies.
Motion to adjourn.
So moved.
Second.
We're adjourned. Thank you.
Okay, so you're doing those.
That's pretty.
I think they're probably.